Good morning. Good morning, dear friends. Good morning, dear colleagues. Good morning, esteemed participants of the seminar. Today, in my official capacity here, I will speak Russian. However, I'm always ready to speak English and, sometimes even German. But today, I would rather speak my own language. Welcome. Welcome to the conference on the auspices of the St. Petersburg International Legal Forum. The mere fact that this conference is held here in the Netherlands means a lot for us. It is rather a symbolic event. Our legal tradition goes back not only to German legislation, as people usually think, but also to the Dutch tradition, especially in the civil code. The civil code of the Russian Federation, as some of you may know, followed in the footsteps that almost copied the latest Dutch civil code. So it would not surprise anyone that our cooperation, especially in the legal area, becomes more and more close and intensive. At today's forum, we will discuss very complex issues, very important issues dealing with the development of the legal culture, with the development of law in general and development of its certain parts and procedures. I'm honored to give the opening speech right at the beginning of our bilateral year. The bilateral year of Russia and the Netherlands is an important step allowing us to boost the development in many areas. Development of business, for example. We may even call that the most important factor because it is up to business to bring in the money, which will give the possibility to develop all the other areas. Politics. Politics is another important issue, and we planned different events in different formats. Today's forum will be followed by a forum in St. Petersburg in May this year, which will receive a very prominent delegation from the Netherlands. And the major key participants have confirmed. Participants from the Russian side will be top level. That forum will be followed by the Economic Forum as well as a number of other events. Cultural component should not be forgotten here. I will go to Amsterdam, to the Hermitage, and I understand that a number of exhibitions which Russia will bring to the Netherlands will allow people to enjoy the masterpieces of culture. And Dutch masterpieces will, in turn, travel to Russia and be enjoyed there. Therefore, I hope that today's forum will become a major starting point for the bilateral year. I would like to wish you all interesting discussions, productive discussions. I hope you can share information on bilateral cooperation developed by the Ministry of Justice of the Russian Federation and the Ministry of Security and Justice of the Netherlands. Thank you very much for the support and for the cooperation which has established between the two ministries. Everybody who is interested are welcome in May in Petersburg. Believe me, Petersburg is a wonderful city, and the so-called White Nights are approaching. And I'm quite sure that we'll have a chance not just to work, but also take a walk on the embankments of the Neva River and the canals and enjoy the architectural monuments of our city. The format we all chose is new and even unique to a certain extent. We had a similar event in London this year, but it was on investment law and the copyrights Rome is the next place for a similar forum on March the 22nd, dedicated to the interaction of law and economy, as well as the protection of cultural heritage. As you see, we try to cover all the areas of law step by step. We try to deal with different areas of law development and procedure development, everything that has to do with the different areas of law. Development of mediation is one of the topics in our today's forum. The topic is quite complex and new for us. The conflict resolution procedures are, as we see them, key procedures if we want to continue building the state governed by law. What we're talking here are the prejudicial settlement of conflicts, whereby a mediator tries to bring the parties to amicable settlement. And only in the recent past, my country adopted an applicable law. On January the 1st, 2011, or the law on mediation came into force. So what we're doing right now, we're creating the relevant procedures and we're promoting mediation. We are developing the legislative norms. We are trying to promote this particular settlement resolution method, and we're talking to the authorities who are potentially interested in mediation. The most difficult aspect here is how to apply the mediation procedure in the public domain, in conflicts in public domain. Here we can talk about administrative conflicts with the tax authorities and with the public authorities. This topic is extremely new for the Russian Federation. This is not a part of our legal tradition. So civil servants need to get used to that gradually. Therefore, people who are in a conflict situation with state authorities need to get used to that, which is not easy. Therefore, we'd like to learn from the best practices available in other countries. Exchanges between experts, exchanges between judicial authorities, exchanges between mediators and public authorities are of crucial importance, allowing us to exchange best practices and learn new skills. I do hope that our cooperation is not limited to the bilateral year. I do hope that the year will become only a starting point of future interaction between different institutions dealing with improvement of law application. On our side, we're all prepared to work together later on, and I do hope that you are prepared too. And I hope that today will show that we all have a very positive opinion about that.
Let me start with a number of with a list of topics I think is important for our discussion. It is not exclusive. It is not. It's not a closed list, but I hope that participants will touch on those issues in their speeches. So first is mediation is the appropriate and efficient extrajudicial tool of dispute resolution under globalization. And the headline of our discussion is mediation in transnational disputes. So this aspect is really important. The second is the role of court system and judicial community in successful integration of mediation into the system of dispute resolution. Next one is public disputes, including tax-related, and importance of using mediation for their resolution in terms of societies and states' interests. Protection of intellectual property rights and mediation. And finally, developing professional community of mediators, quality of mediative services is a prerequisite for successful spread of mediation practice. Those topics, I think, will go through all the speeches that we will hear, and let's have a productive discussion. And I propose to start with our Deputy Minister of Justice, Elena Borisenko. She is leading person, one of the leading persons in the ministry, and we take part in all kinds of discussion about new legislation that is coming forward in Russia in many areas, including mediation. Please.
Thank you very much. Thank you very much, Your Excellency. First of all, let me say my thank you to all of you coming here and all of the distinguished speakers who agreed to join this panel. As I think that is really important for us, for Russia, the country which started developing mediation as an institute recently, to have such opinions on this theme from the very experienced in this sphere Dutch and Russian experts. As it was said today that we have a special law that was adopted in 2011 on mediation, and we still think about how to improve this law and how to make the mediation come to our society. And I have to be frank that not very many of professional lawyers do believe in the efficiency of this institute right now. But as we look to the European experience and maybe American experience, we see that this way of solving the disputes is very efficient and cause the decision between the sides in the very short period with the low costs. And I think that is really important to, especially in the global world when the national jurisdictions become more and more dependent on the international one. And it is really important for the integration processes and then for good investing to have alternative ways of solving disputes. And I don't want to take a lot of time because I don't feel myself very skilled expert in this side, though I do responsible in the ministry, and I always ask my colleagues, experts, and most of them are here in this panel, our experts who are involved in our discussions. I think that we will have lots of questions today, and if Your Excellency don't mind, I would be happy if we could pass these words to the Dutch and Russian experts. Thank you.
So, what do you think about the development of mediation in the resolution of disputes regarding intellectual property rights? Can it help, really?
Thank you very much.
Dear colleagues, indeed, today I'm holding the first speech as the chairman of the court, and I'm very pleased that I can celebrate my birthday in such a distinguished community. It seems to me that the tasks are still being tabled by the Court of Intellectual Rights can only be resolved if we're able, in the activities of the court, comprehend and take in all the positive experiences that are found in the world. In translation, the meaning of the court sounds like this: intellectual property court. So this is the intellectual court, as many say. So our task and our objective is the very best, the most interesting experience we can find to receive it, to accept it, and use it in daily practice. I have to say that the establishment of the Specialized Intellectual Property Court of the Russian Federation, this is the first specialized court, was a result of a long-standing negotiations and work, a very serious struggle to have this direction emphasized to such extent. And as a result, today we can truly guarantee, I hope we're able to guarantee at a particular level, the protection of the intellectual property of the Russian Federation. Indeed, we do need help because this is so new for us. This is just a startup. And we're ready and we're open for all the possible intercommunications, promoting and enhancing the activity of the court and resolving such delicate issues. I think it would be right to say that one of the first steps that were undertaken immediately after the court was established was the measure of meeting of Russian mediators. We're very well aware that in such delicate sphere as intellectual disputes, we can not only rely on the force and power of the state. When parties meet in court, mathematically, it looks like this. Two opposite vectors, they are in conflict. And the conflict annihilates the positive side which could be found if two sides would understand how to resolve the conflict. So in my opinion, mediation allows us from the opposite action, which is really detrimental and does not yield any positive results, bring those opposing parties to a different level. And we remember mathematics. If we understand that vectors are running parallel, it means there is some positive direction in which the conflict can be resolved. And it does not make conflict a conflict. This is a joint effort to go and achieve a certain result. And we understand that we need to bring the parties to a single-minded solution and not to increase the conflict. So as the first event, what we planned was a broad spectrum of future measures which we would like to implement with Russian as well as international organizations on mediation. The way we see it, we have a need of creating a strategic program of development of partnership of the Court of Intellectual Properties and associations of mediators. Within this framework, we would like to teach the judges who need to be taught the art of mediation and to bring the education, a legal education, to a certain level so we can train our lawyers to resolve conflicts. Well, the lawyers usually live a very opposing and struggling life. They see enemy in everyone, at court, in their colleagues, and the state is their enemy. But as a matter of fact, it's not true. Many people say, yes, life is a struggle, but in my opinion, life is a cooperation. And taking a joint action, cooperation, it's a mutual action. It has to be mutually beneficial. So from this conflict situation, we need to take these parties out of that stance and not to escalate the conflict. And so the Association of Mediators understands our plan to a full extent. So in the nearest future, we're planning to organize several seminars, so training seminars for the civil servants, for the judges, to teach them the techniques of mediation. We would really like to have a strong service of mediators by the courts so that they would direct the parties and implement the techniques and methodologies if the conflict arises. The service would be instrumental in taking the pressure of psychological pressure of the parties when they come to court. And I think we would also like to think of different events and ways to do that. There are many courts that take that practice. There's a mediator service. There's certain mediators on duty all the time. And they work effortlessly and without any pay to assist the court, and it's a big help. I know that many judges also use that particular support in mediation, a psychological support. I think it would be very useful within the framework of the courts to have certain trained individuals who would implement those techniques in practice of mediation. Which is very interesting is to have a list of mediators with a court. It's like an open list of specialists who could be involved in dispute resolution, even in our court, which are very specific indeed. You know, everything that I have said prior can be applicable to any court, and probably in our court is so important because we're dealing with authors, with the creative people, and those people have put their soul into their art, and if they see or feel that they're being hurt, they really protect their creation as the mother would protect their child, and the level of the conflict in this particular area is so much higher than in other fields, particularly if you're talking about, say, goods or trade, because the creator or the author is personally involved in this conflict. That's why the procedure of mediation in the issues of intellectual property is of essential importance. I looked through statistics, and what I saw is to what extent the parties are ready today to cooperate, to have the mediation agreements. And the statistics is not very specific but clear. It shows that 15% of all the disputes in this particular sphere, the parties are ready to resolve their conflict and differences. And this is a resource which could be used by involving mediators. I think 15% is a minimum threshold, and our task is to resolve those disputes through mediation to up to 22 or 25%. This is my dream. This is my blue dream. And in conclusion, what I'd like to say, we're open to any kind of cooperation. We would be more than happy to receive the experience of other countries, and we would also share our experience of using mediation in intellectual disputes. I would like to thank you for your attention, and I think within the framework of the St. Petersburg International Forum, we will have an opportunity to present certain facts and tell you more about this specific court of the Russian Federation on intellectual property, and we will have an opportunity to discuss it in further depth. Thank you.
Thank you.
Developing mediation in Russia. But I'll just be solidar with some of my colleagues, and I would prefer to talk in Russian, if you don't mind. So,
we started developing mediation in the beginning of the 2000s, and as of today, what we can talk about is that a lot has been done already in Russia, but on the other hand, we wish for the situation to develop in a more dynamic way. We heard today already in the previous speeches of our panelists about arbitrage and different hybrid forms of mediation. And I believe that most of you understand that mediation is one of the correct and adequate ways of resolving disputes of the 21st century. Yes, we all come face to face with these challenges and contradictions that the world is presenting before us today, the globalizing world, and it is vital importance to have and to keep this identity and at the same time integrating into the common space. into the socio-economic and socio-commercial. So this way we cannot talk about developing different conflict resolutions at the national level only. We're all integrated into the global space and international community. As of today, there are a lot of things done in Russia to that end. We have the legislative foundation, which perhaps is not quite perfect. And the world experience also says that the mediation falls into its right place after the certain experiences gained. However, there are also some cultural specifics. So the exception of the mediation law in Russia, one of the key steps in development of that particular area. And it probably need more development in the future. But what is important is that in different fields, and even in the government field, mediation would be included as a normative and legislative foundation. Because we all understand, and not only in Russia, the situation is as such that it should be done. The world needs stimulus for the community and for the society, for development of mediation. Despite the fact that this is the most essential way for the parties to resolve disputes, and it helps like no other method to come to a solution, except negotiations, of course, and to also stand by their interests. What is important is that the parties need to have an incentives, and which are also based and rooted in the law. We're talking about administrative disputes and commercial disputes. And one of the panelists will also share the experience of the Netherlands. And we're really optimistic when we hear of this experience. And for several years, the Ministry of Finance and the Russian Tax Service are making joint efforts to integrate certain elements of mediation into the work of the tax authorities. We also have legislative initiatives in this respect, which allow us to regulate the conflict, administrative tax conflicts, in a much better way outside the court. One of the key elements is the Association of Judges. And we were asked a question that the Supreme Court judges are not very happy of the way the mediation is developing. One organization, one person, or even a small group of people cannot do much, particular in such a vast country as Russia. Hence, from the first days of mediation and integrating mediation in Russia, we understand that the community of judges are of the essence. And it's very important that Lyudmila Alexandrovna is here. And by creating the Court of Intellectual Property, and one of the first key issues was Veniamin Fedorovich Yakovlev, who was the advisor to the president, and Madame Novoselova, who were also pointing out how to integrate mediation in this sphere. And it's very important to us for mediators to put forth effort to support mediative practices at a certain level. A lot of effort has to be taken to develop this area. And in this respect, we talk about a bar association and legal associations, and also association of corporate counsel. Those are the groups which are, just as the judges, are the keepers of the information. And what is of utmost importance is that the lawyers themselves and jurists understand the importance of mediation as the way allowing, first and foremost, to themselves to follow and to be the examples of professional ethics, and using the optimal methods of resolution, such as mediation. And these methods are adequate. What I would also like to add at this point is we're part of the international community. Russia is a member of the WTO, and using a mediation and cross-border disputes has a lot of positive sides. First of all, this is a qualitative resolution of disputes. This is the way which allows us to go beyond the jurisdiction level and find the solution most satisfying to all parties involved, even taking into effect when there are so many parties involved and conflict is of a very serious nature. At the same time, the use of mediation in cross-border disputes or transnational disputes is also a moment, we can say, of enlightenment or raising of awareness. Suggesting a mediation by the foreign partner is very often an impulse for the Russian party to use mediation in order to gain experience in participating in the procedure for mediation. I understand we're short of time, but what I would like to say is that we are here in The Hague, and such organization as a Hague conference and play an enormous role in using a mediation in transnational disputes. We're currently working very hard on the convention of the 1980s and 96, where mediation was brought up as a broader spectrum. We have certain agreements which we're discussing with Mr. Bandu of possibility of including mediation in commercial disputes, so it will have a more broad reflection in conventions pertaining to business or entrepreneurial activities and disputes. And perhaps the Dutch side could be the initiator of such propositions so that the Russian partners can also continue in this respect. So it's very important that the international community helped National Association of Mediators. This road is a mutual walkable road. One of the most important factors here being the quality of the mediated techniques and services. And I do hope that this seminar today will also help us to promote mediation in Russian Federation and give us an additional impulse and incentive in developing Russian-Netherlands relations, particularly in the area of business. Thank you.
Willem Kalkoen, I'm a board member of Prime Finance, and I have a question to Justice Novoselova. Thank you for your very personal speech emphasizing cooperation of lawyers. When your courts have a list of mediators, is that, and the mediations, are they international mediations? That's my first question. And the second question is, how do these lists work? And the third is, do you as a judge really ask a specific mediator, or do you just say, here's the list and you choose?
Thank you for your question.
Right. If you allow me, I would like to take you back to the beginning of my presentation. The point is that our court is very young. We're not even a month old. We're just a baby. What we're doing right now, we're just setting it all up. So we don't have a ready-made list of mediators yet. What we're doing right now, we're compiling this list. It will be an open list of mediators, and I don't see why it cannot include those mediators who deal with transborder disputes. It can be mediators from abroad, experts in mediation, and also people who specialized in intellectual property conflicts and disputes, because intellectual property disputes are of a very particular nature. As far as your second question is concerned, I would like to say that when a court comes up with a mediator, is not a suitable situation. This is not suitable for a regular procedure. I believe that it is up to the parties to choose a mediator, but there should be choice. If we have candidates who are experts in that area, we'd like to be quite transparent. We'd like to openly provide the information to the parties about people we offer to them as mediators, experts in this particular field. And it is not up to the judge to come up with a certain name. It is up to the parties to choose. The judge should professionally evaluate the necessity to turn to mediation. The judge should somehow guide them and voice the possibility to involve a mediator. But a judge shouldn't really give a name. This wouldn't be correct.